Good afternoon. My name is Dwight Mitchell. That's DWIGHTMITCHELL. I'm the founder of Family Preservation Foundation, a 501c3 organization dedicated to rescuing children that have been removed from families by Minnesota Child Protection Services. When I say rescue, we're talking about on grounds we feel are unconstitutional based upon the state statutes. Most of you know us by our program name of Stop CPS from Legally Kidnapping Children. We're an association of parents that have grown to over 4,400 members in approximately 120 days. We seek to provide legal aid, guidance, and services to all families involved with CPS proceedings, more specifically to low-income families who cannot afford attorneys. Today we are here to celebrate the rescue of Xavier Weber and the reuniting of him with his mother after what we believe were 4 months of unconstitutionally forced separation. We will also provide you with the details behind the case, as well as answer questions regarding our victory in our inaugural state case. We are extremely pleased with our win in the Amanda Weber case. Who wouldn't be? Well, outside of the state who lost. But one of the things that makes this most interesting, this is our 12th assisted rescue. We've helped other foster moms like Marlise James, Daisy DeWitt, and of course Amanda Weber as families who have had their children unconstitutionally taken by Child Protection Services. As many of you are aware, the goal of Family Preservation Foundation is the preservation of the family unit. That means we are actively pursuing, preventing, and undoing unconstitutional removals, as we like to call them, legal kidnapping, as soon as we hear about them. This includes cases like Amanda's, where parents have had their children removed when there was no harm to the child. This is specifically as it relates to fabricated evidence, misleading court information, and/or withholding exculpatory evidence. Through fundraising, we seek to expand our legal aid program by hiring staff attorneys and opening additional offices throughout Minnesota. When I first mentioned that Minnesota Child Protection Service was unconstitutional, removing children from families where there was no harm to the child, everyone in the media doubted me. So I decided to prove to you firsthand what happens in a typical child protection case. Now that this case is concluded, I will outline the case and present it to the public in a video format similar to an investigative report. And that's to come probably in the course of the next 30 days. I will present what we feel are unconstitutionally flawed state statutes and show you how an innocent mother can be separated from her child and then retained by CPS for months. Furthermore, I will review in detail the court transcripts and evidence so that you can see exactly what transpired and why Judge Wheiler ruled that Xavier was not medically neglected and that false information was intentionally provided with a deliberate intent to deceive. The truly sad part is that this is not unique, but normal. I have had another mother, Kim Duffney in Wright County, call me just this past week where her 2-week-old child was removed from the house simply because the house was messy. I vetted the case, I've looked at the court transcripts, and that's exactly what it says in the transcripts, that the house was messy. So long story short, the house was messy. The family had just moved into the new house. Kim required an emergency C-section. She had been home for 2 weeks recovering from major surgery while trying to take care of a newborn and her 3 other children. And instead of social services coming in and giving her aid by saying, let's bring in a visiting nurse, let's have somebody help you clean this house, they in turn turned around and took all 4 of her children. And what she really needed was aid while she was recovering from her major surgery. Unfortunately, the laws that regulate Minnesota Child Protection Services are so poorly written and unconstitutional that the rights of parents and children are being violated on a regular basis. Case after case is being written up on a regular basis by social workers with unfounded and uncorroborated accusations and allegations to make parents look like monsters, which will allow the social workers to establish a prima facie case before the court in order to remove the child with no evidence or harm. Minnesota does not require a showing of harm before the court before a child is removed from the home. The parent is automatically guilty until proven innocent based upon hearsay. Well, even if the allegations were true, even a monster and children have constitutional rights. Social workers should have substantiated their claims of harm with evidence. Children have a right to remain with their parents and alleviate the stress and trauma of separation unless there is harm to the child. By state statutes, case must be brought to trial 60 to 93 days after removal. In Amanda's case, her 10-month-old son was removed from the family home and traumatized for 120 days before being reunited with the mother. Only to have found out that what the mother said 120 days ago was ultimately correct. The United States has an adversarial court system. There is a prosecution and a defense. The defendant is innocent until proven guilty. Nowhere is the system more broken in Minnesota judiciary than the cases relating to child protection. In no other civil or criminal court proceeding is the adversary ordered to help the opponent win the case. It defeats the entire notion of due process, innocence until proven guilty, and a fair trial. Yet this happens in Minnesota on a daily basis. Don't believe me? Just look at any findings of fact, conclusions of law, and subsequent orders from any CPS petition, filing, or emergency protective hearing. Parents are ordered to cooperate with their adversaries by the judges, and this is wrong. In fact, Minnesota parents do not have to cooperate with their adversaries. Social workers write up case plans and ask parents to sign it and state the services before the trial have begun. So a parent hasn't had a trial, hasn't been found guilty, yet they're required to do these services and these tests. Furthermore, parents are penalized by the court if they do not follow the recommendations of the social workers before the trial has even taken place. In Amanda's case, Judge Wheiler actually admonished her in his final opinion for not cooperating with her adversaries and called her immature for exercising her constitutional rights. In 2016, 15,004 children were removed from their families in Minnesota. Minnesota spent $505 million on child welfare service in 2016, excluding court costs. Over the past 15 years, 211,403 children have been forcibly removed from their parents. Minnesota has significant racial disparities for over 15 years. African American and American Indian children are disproportionately likely to experience out-of-home placement. 80% of the children were kept from their homes for over 3 months. Compared to white children based upon population, American Indian children were 17.6 times more likely to experience care. Children identified as 2 or more races were 4.8 times more likely to experience care, where 59.2% where at least one race was African American and 56% were identified as American Indian. African American children were 3.1 times more likely to experience care. Children under 2 were more likely to experience out-of-home placement. And last year, 2,673 children under the age of 2 fit this category. In June of 2018, the Children's Defense League and 540 organizations from all 50 states, the District of Columbia, and Puerto Rico sent a letter to the Attorney General with the Children's Defense League stating that the separation of children from their parents will have significant and long-lasting consequences for the safety, health, development, and well-being of children. I'm a management consultant by profession, so we're a data-driven organization. It was the federal and state reports, which I have links to on our website, which caused me to start this organization. I urge you to go to our website, review the links, and validate the information for yourselves. They're all on the federal and state websites. Currently, the Minnesota system should be abolished and re-engineered. Thank you. Now I'll let Amanda Weber tell you her story and how it feels to be reunited with her son Xavion after 4 months.
Hi, my name is Amanda Weber. It's AmandaWeber. I have recently, within the last week, become reunited with my son Xavion, who was taken approximately 4 months ago. It's been a long and daunting process. I have hit roadblocks every single time that I've been to court, or I couldn't seem along this process to get through to the court. I've been innocent. I've not medically neglected my son or abused or neglected any of my children in any way. And from the very first court date, I provided that to the social worker, Katie Knittel, who was on my case. And so before the petition was even formed, Katie Knittel, the social worker, she had the information that my son in fact was not medically neglected, and I had in fact met all his needs and had provided for my son and his diagnoses. And so at the last trial, we went through the trial. I was questioned. We presented all the evidence, most of which we've had from the very beginning. And after that, the judge took approximately 14 days to give his decision. And in his order, he had said that I was not guilty of medical neglect, but that they were going to keep my child just a little bit longer because they were unsure of my, I suppose, household, and was it safe for my child? Was the place that I was living appropriate for my child? So they, this guardian ad litem on my case, Amanda Rocco, she drove all the way to Wisconsin, where my residence was, and she looked through the house, said she had no worries, said that the house was good, that my place of residence was appropriate for my son to be returned to me. And then also a Dane County CPS worker, Morrison County had a Wisconsin CPS worker come to the place and also do a walkthrough, and he had also said that he had zero concerns about my son being returned to me. And so on September 11th, the judge, as Dwight had stated, scolded me for taking advantage of my rights to have a lawyer present during all processes and all situations throughout my case, but said ultimately he had to think of the child's best interest, and the child's best interest was to be returned to me and his family, and so then that happened.
Okay. Thank you. We're going to have Rhea Borman as the lead attorney speak next.
I'm Rhea Borman Spears, last name is Bornmann Spears, Spears, first name is Rhia. I was Amanda's attorney originally by myself on this case, and then luckily through, I believe we should give Dwight the credit, Eric, and then eventually Bill Mormon also joined the case. And I have to say that I think probably the most concerning piece would be the fact that it took 3 lawyers to pressure the judge to do what was right. And Amanda is absolutely right that she had given all of the crucial information over to the court, to the judge, to the social worker. Everyone had that information back in May. So the petition was signed on May 29th. One of the things that came out during testimony was that the social worker, Katie Knettel, had had a conversation on May 24th with the doctors and the medical providers to learn that 2 of the conditions that were written in the petition were no longer true. She had that information before she signed the petition on May 29th to know that she had been given false information by Nurse Veda, the primary care nurse that my client had been seeing with her child. What's most important is that despite all of that pressure from the 3 attorneys, from Amanda handling her case pro se in the very beginning days with the help of Dwight successfully shoving all of this information in the court's hands, it still took 120 plus days to reunite mother and child. I think that Amanda was a very lucky individual to have connected with Dwight, to have had attorneys come to her aid, and it still took that long. And the judge, based on the lectures that we received, made it very clear that he did not want to hold the social worker accountable, he did not want to hold the nurse accountable, and the only person he seemed focused on holding accountable was both my client and even myself in questioning my withholding of releases when wrongful information was given by the county attorney at one point. He even took the time, despite the dismissal in the end, to lecture my client, as discussed, about immaturity and about her obstinance. And essentially, I would say, said it was her fault that this case had drug out as long as it had. If she had just been cooperative in the beginning, etc. Well, that's another point that we made to the court. The social worker violated the statutes that are written that would have prevented removal of this child from the beginning. There is a statutory obligation to develop a safety plan with the child so that they can stay in home and not experience the trauma of removal. The social worker in this case actually used law enforcement to ping the phone of Miss Weber and find her and her child, go out there with deputies, get a hold order, and remove the child from her care, all before ever having a conversation with the mother about these medical allegations. I don't know about you, but I find it pretty scary to think law enforcement can ping my phone without me knowing about it and come take my child. And Amanda did everything right. Not only did she video these scenarios, so we had the proof after the fact, but she shared them with us so that we could see. She questioned the authorities, she was appropriate, she did not become outraged, she did not become irrational, she did not insult them, she was not violent, there was nothing inappropriate. She simply questioned, I want to know why my child is being taken. She tried to exercise the rights that we would all assume we have in that situation. She asked the social worker if there was any other arrangement that could be made to keep the child in her care. She even threw out her own parents who had been foster parents previously. There was no working with this social worker. And then my most, the piece I'm hoping that Dwight will come through on at some point is helping us figure out how we can address the fact that that social worker at the end of the day, she has immunity. Not only did she have the judge protecting her from being held accountable, in my opinion, but she has immunity in the law. And she will not be held accountable for what was done, even though the evidence came to light that she did not do what was in the best interest of the child. And I would like Amanda to talk about, after she was reunited with her child, what she's seen. Because I believe it was also relevant that when I questioned the guardian ad litem and the social worker about what kind of training they had received about the trauma caused to children with the removals that they are doing with their wanton disregard for the family unit, that she said they had minimal to zero training. So I would like that issue to be addressed further, and I think that Amanda talking about her personal experience with her son would be helpful.
There are two things that I would like to say. I will touch on what my lawyer just said, but I would also like to say that I am angry and I am upset. I am mad at the system for failing me and my son. And the fight isn't over for me. I will not stop, specifically until Katie Cannell, the social worker on my case, and nurse practitioner Wheiler cannot hurt another child or another family or rip them apart again. And I will not stop. If it's the last thing I do, I will hold them accountable. I won't stop, and I want them to know that. And also, since my son has been home since September 11th, he has showed signs of being traumatized while he was gone. He has a hard time if I'm not even in the room. If I leave the room or leave his sight for even 5 seconds, he's screaming as if he's traumatized. The day they took him from me at nurse practitioner Wheiler's office, when they took him from me, he screams like that. Just like he screamed when he was taken from me, he screams like that now when I even leave the room. It takes hours and hours to get him to bed. He was removed from me, traumatized. The very next day, put into a hospital. No one was by his side, so not only did they remove my son from me, but that same night they dropped him off in the hospital. You know, no foster parents there, nobody there to hold him. He was completely alone, except for the occasional nurse, I'm sure, that checked on him while he was there. And so he is not, you know, I was hoping he would receive minimal damage from this, because damage to him he was taken when he was 10 months old, so the damage is inevitable. But it seems to me that right now I'm dealing with trying to help my son, because they hurt my son and there's nothing I could do about it. I had to sit there. A parent's worst nightmare is to watch their child be hurt and not be able to do anything about it. I have lived my worst nightmare. I have lived what I would never wish on my worst enemy. In my life, all the pain I've ever gone through in my life would never amount to the amount of pain that I've gone through in the last 4 months. And in my humble opinion, and for lack of better wording, I will not stop until these monsters, these people who take children, the majority of the time, without substantial evidence, until they're held accountable, each and every one of them, and until the laws are changed to where this cannot happen. I think that's all I have left to say.
Thank you. Eric Cordell, our Chief Counsel.
Eric Cordell, K-A-A-R-D-A-L. Welcome, everyone coming in. So I'm the Chief Counsel, and I was the one that filed the federal lawsuit on behalf of the association in Dwight. And then the state lawsuit, Amanda Weber, I participated in as one of the attorneys with Rhea, my partner, Bill Mormon. And so Dwight is a very sophisticated businessman, management consultant, worked with multinational corporations over the last 30 years. He knows how to run a nonprofit. He knows how to run a sophisticated litigation strategy. The sophisticated litigation strategy here is to file the federal lawsuit on behalf of this organization now that has over 3,000 parents who are victims of similar incidences. And then the idea is to proceed with state lawsuits to show that the federal lawsuit is valid. So here we have a state court lawsuit. We know from our research on the state statutes that these state statutes regarding child protection services sort of evolved from the juvenile court. Remember, juvenile court, we commit these juveniles to centers as opposed to putting them through the regular criminal process. Well, from that juvenile court procedures, we got into this child protection services. And you know, in the same definition, we have child in need of protection or services, which includes neglect and corporal punishment. We have truancy, that means you don't show up at school, and runaways. I mean, you start looking at the statute and how it's evolved, the definition of CHIPS, Minnesota Statute 260C.007, and it's barely understandable. I mean, barely understandable, and everything's thrown in there. And then now the Child Protection Service in the counties use the CHIPS definition to seize children at the front of the case. And it's so confusing that when we say, look, you can't seize the child without having a constitutionally justifiable reason to do so, which basically means substantiating substantial harm to the child, right? It's so confusing that Child Protection Services is confused. Can you believe that? That we go to court and we say, look, there are constitutional requirements before you seize a child from a parent. And the CPS looks like we're like from Venus or Mars. It's the most astonishing thing. In the court proceeding with Amanda Weber, we brought up parental rights, and they were completely disregarded. In fact, I remember the words of the guardian ad litem attorney, basically the paramount or only concern is the best interest of the child. Well, we're concerned about the best interest of the child, but the constitutional rights reflect that. Think about this. The constitutional right of a child is to be with a parent without government interference unless there's some substantial harm occurring to the child. Seems pretty normal, right? But when you're involved in this child protection proceeding, the guardian ad litem, the state and the county give zero weight to the fact that the government has separated the child from the parent. Zero weight. What does that mean? That means that your Child Protection Services, your Department of Human Services, disregards all medical testimony, all medical experts. I've been talking to medical experts, and the state comes in and, no, we can seize that child because there's no harm done to the child or the parent. But that's not what Amanda's testified to. That's not what Dwight's testified to. They've testified that when the government separates a child from a parent, there's harm. Now, I've talked to medical experts. I've talked to psychologists. I've talked to people, and they say when you separate a child from a parent, there's harm. But Child Protection Services, they seize the child at the beginning of these proceedings. And the statutes do not require them to have evidence to show substantial harm. There's two parts of that. Our neighbors in Wisconsin, prior to the lawsuit being filed to seize a child, they have to make an agency determination substantiating the charge, and then they require evidence of substantial harm to the child. Here in Minnesota, we don't require an administrative decision substantiating the charge. The social worker does it with the county attorney and only has to show a prima facie case, which means they basically have to show there's an allegation. And then, unfortunately, in these standards in Minnesota with neglect and also with ordinary corporal punishment, the state has standards that are so low that they're really, it's almost impossible to win one of these cases. As Rhea was saying, you've got to have 3 attorneys and you got to pound on the podium because the law isn't on your side. In other words, where are these standards? The government's always right because they have an allegation. Now, at the end, the judge said, if Amanda had cooperated, she would have received more government services. I think he missed the point. Amanda was saying her child should have never been taken. She didn't want the government services. And so we have a real problem here that involves the people's understanding of family, and that is the family should remain intact unless there's substantial harm to the child. You have the agency, which will take children from parents without proper justification, harming the child. And then the agency has basically written the playbook for the state court judges. And so the state court judges are with the agency. In fact, the agency has drafted a trial book for the judges to follow in these trials. So you have the people, their sense of family. You have the agency rejecting the people's sense of family because they take these kids unnecessarily. And then you have the courts with the agency. And so we have this big conflict. And the state court judges aren't doing anything. They're just playing along because that's what the statutes say, even though they're obviously, the standards are unconstitutionally low and they're not required to substantiate before filing a lawsuit. So then what we do when we have this kind of a conflict, well then we go to another judicial system, right? Even though we're proving that the children are being unnecessarily taken, Dwight's federal case is basically, Well, the people have a concept of family. The state agency has its concept that rejects what the people believe. And then the federal judge, of course, refers to what? The Constitution, right? And it happens to be that the constitutional protections of parental rights perfectly correlate with what the parents want. What the parents want is to be left alone if there's no substantial harm being done to the child. And that's not what the state agency and the county agencies are doing. They're unnecessarily taking children and then basically, after the fact, sort of proving whether they should have taken the child or not. And it's not supposed to be that way. There should be a pre-deprivation hearing before the child's taken. And Minnesota has gotten into this. And there are many reasons why I believe the state agency and the county agencies operate this way. The federal funding, follow the money. There's a sense of power, entitlement. No one else has ever criticized them. The journalists tend towards stories that are horrific parental abuse of children, but they don't cover the horrific abuse of a parent like Amanda or Dwight when they lose their child for a long time. So what we want is balanced coverage of this, that the agency, granted, has a lot of power to grab children from abusive situations, but they shouldn't use that power to traumatize families like Amanda's and Dwight's. So what we're looking for in the state court proceedings, and we have plans to do dozens of these to convince you and the people of this, that we'll continue to vet cases to find instances where the government has unnecessarily taken children and try to convince state judges that they should let the children go. And you may say, well, isn't that a fool's errand, Mr. Cardall, because the standards are so low that they can take the child on any sort of allegation. And we know it's a fool's errand, but as we participate in those cases and continue to rescue them, as Dwight mentioned, we'll inform the federal court of our successes and our failures, and we believe then the federal court will resolve this issue in our favor. Again, with respect to the federal lawsuit, we're looking at substantial harm, and so that means we're really focusing on neglect cases and ordinary corporal punishment, because in ordinary corporal punishment cases, there isn't any harm to the child either. And in Minnesota, laws uniquely say that ordinary corporal punishment is okay with respect to the criminal law, but of course, under this CHIPS definition, they can seize the child for even ordinary corporal punishment. Thank you, Dwight.
Thank you, Eric. I was wondering if there are any questions from the press at this time?
Yes, you say that Judge Wheiler found that false information was intentionally provided. That's not his finding. He found that he never even examined the source or the rationale why that information was provided. So I think, are you exaggerating a little there, or do you know something?
No, I'm not exaggerating. I was at the trial, and so the order specifically says disinformation or misinformation.
He says that it was present in the case, but he does not attribute it to false information being intentionally provided. He said he wasn't going to even examine that question.
Well,
but didn't.
But you had to, I'm taking liberty because I was at the trial, and
well,
so.
If we take liberties,
well,
we as a press are going to take a step.
And when I say take liberty, it's not an interpretation. I looked at the misinformation that he spoke to, and he said it was with nurse practitioner Wheiler and Katie Canetto. So he mentions who the misinformation was for. What he failed to do, and that's what Rhea was talking about when we talk about protection, is he didn't elaborate in his findings. He says, I'm only going to say that the child wasn't medically neglected. So that is a cover-up because the information is there, and if I send you the court transcripts, you'll see that the information is there, and that you will see that we, as Rhea mentioned, when we impeached Katie Canetto, that was the only time the judge actually got riled or ruffled when we actually went after the government official. So I'm not really taking liberties. He didn't elaborate, but it is in the transcript, so it's available for you to look at. You can get the transcripts and you can see.
I've already asked for them. I'd like to see them.
So have we. So what I had mentioned earlier is we plan on doing an investigative report, and I'm going to actually detail, like, here's the state statute, here's what we provided the information, here's what Katie Canetto knew before she even filed her petition that nurse practitioner Wheiler had given her false information. And it's in the court transcript. So it's not something we're trying to hide, and I specifically mention it because I don't want people to take my advice. The whole reason I did this case, when I say did this case, took Amanda's case on for the foundation, was specifically to show everyone what happens in these proceedings. This is normal. And when you read the documentation and read the transcripts, you'll see exactly what I'm talking about.
Ms. Weber, how did you described how he's changed, but what was your reaction to, how did you feel about getting your son back?
I felt relieved. I felt like half the battle is over. I felt like I finally got my son back, and it's obviously a very happy time, a very exciting time. It's just what I guess what I didn't think would happen was what I'm dealing with my son right now and the damage that they've caused him. And it's just this whole system, like I said, failed my son. So it's a bittersweet moment. There's good and there's bad in getting my son back, because now I have to deal with the consequences, them damaging my son having anxiety, my son, like I said, my son screams if I leave his sight, if nobody's holding him or touching him, or paying a lot of attention to him. He was never that way before, and he is still himself in that he's an incredibly happy baby, but there will be moments for no apparent reason where he'll break out, he'll scream, he'll cry, and I won't know what's wrong, or I'll set him down, or I can't cook dinner without holding him in one arm. And those are things where he's having a hard time being independent. And so that's why I said that I am so angry and I'm mad and upset, is because they now have said, well, you're not guilty of medical neglect and there's no reason to keep your child from you. But are they held accountable? I don't know. It's kind of like a big whoops. Whoops, I guess you're right. You didn't medically neglect your son. You didn't abuse your son. But you know what? Now we'll just hand it back, and now you get to deal with the consequences. I feel like they, as is mentioned, that they should help provide necessary care for damage done to kids, especially kids who should have never been removed in the first place.
One of the things I wanted to point out, specifically as it relates to Amanda's case, is Eric and I had a conversation, and Eric said, well, now the public will know what you're saying. Now they'll know it's the truth. I said, no, they won't. I said, we're going to have to win 10 more of these cases where people will specifically sit and say, Family Preservation Foundation is right. So we're going to have to go out and do case after case and say, where's the harm? Where's the harm? Where's the harm? I challenge you to go look at any petition, Freedom of Information, just look at the petition, and you'll see an allegation. But they never supply you any evidence of harm. And that's because they don't have to. They don't have to actually provide evidence till trial, which is anywhere between 60 and 93 days. So they can hold your child until the trial, which then they're going to say, oops. So I'm asking people not to believe me. Go look yourself. I just want someone to look. And if they will not, then I will continue to expose and continue to expose and continue to expose. We've just, we're trying to hire staff attorneys now. We just started our first fundraiser. So we have a Facebook fundraiser, and we also have it on our website. So we're trying to expand. We've gone from 250 to 4,400 parents. You can't tell me in a 120-day period that 144 people in this state are screaming for assistance and are saying the Me Too and nothing is wrong. I'm saying what happens to Amanda is normal. What happened to me is normal. And I'm going to sit here and I'm going to keep going after these cases until the public understands that this needs to be changed. It's not, some pipe dream. Yeah.
Amanda, I had a quick question about, because I was reading through in the the judge's order, going back over the trial, and you'd mentioned that you didn't want to speak with Ms. Knettel, and I'm wondering if it's, when you're saying that because there were some, you said they've been untruthful in the past, or they've made up things in the past. Are you talking about that you knew that Katie Knettel had that information about that your son was receiving the care that he was supposed to get, and still went forward and was still pursuing this removal? Is that the kind of stuff you're talking about?
Yeah, I guess so. What I am saying is that the disinformation the judge was talking about was from Nurse Practitioner Voida and Katie Knettel, because Nurse Practitioner Voida gave Katie Knettel disinformation, or I guess you could say lies, that I wasn't providing necessary medical care for my son and that he had a real risk of dying. My son never had a real risk of dying, and that's evident now. I didn't necessarily know what in all the information that Katie Knettel had in her hands at the time before the petition, but along the way I did learn that she did have that information before she formed her petition. But it was both Cassandra Voida and Katie Knettel who supplied disinformation in the petition, which got my son emergency removed from my care.
So when they were trying to, when the nurse was calling you after you took your son out of the hospital that morning, after the first, when he was in the hospital overnight, and you took him the next morning, I believe it said that it's like 10 in the morning the next morning, and she heard about this and called you. And of course, according to her, she said you were defensive about it. But are you saying that may be based on the fact that you knew that your son had gotten the care that he needed, and don't bother me about following up? I'm wondering if it's because they're trying to paint you as being you're not caring or something about the condition of your son, but it sounds like you're telling me that you knew that your son was okay and that he'd already he'd been receiving the care that he needed. I just want to make sure I'm clear on that. That's the perspective that you had on this. You were trying to say, look, he's fine, because doctors there had already been information saying that, his condition did not necessarily constitute that he needed to keep having the treatments. Is that kind of what I make sure I'm clear on that?
Well, yeah, there was a lot of them pointing the finger at me, saying I didn't provide necessary follow-up for him. It was all kind of based off the diagnosis of sleep apnea, which he's now outgrown. They had said that I was supposed to have him on a monitor, when in fact the specialist, the lung doctor, I can't remember the professional name for it, the pulmonologist, when the pulmonologist had told me that after a couple downloads off the machine that he was fine, he had no extreme episodes that would constitute continuing keeping him on the machine, but I'm the one who pushed to keep the machine. So what they might point the finger at me and tell me that I didn't keep him on the machine, but I'm the one who pushed to keep the machine for my own comfort. I was waking up before he was diagnosed, no doctor would believe me. They said, well, nothing's wrong. And that's because the case he had of sleep apnea was minor. But I, as a parent, waking up every hour on the hour, finally got sent to Children's where he had gotten that diagnosis. And so, long story short, like I had said, he had the diagnosis. I was told by his pulmonologist that he could be taken off the machine. And I said, I know he hasn't had any problems, but it gives me peace of mind. So I pushed to keep the machine, and that's where they said, and then I stopped using the machine because I felt comfortable at that point. He had no episodes, he had no pauses in breathing that were at least 26 seconds long that would constitute a severe case of sleep apnea. And so that's why I took him off the machine, and they seen that once they gathered the extra downloads. And so, so basically that's what they're trying to say is I took him off myself well, he didn't even need the machine anyways. I'm the one who pushed to keep the machine. I'm the one who went above and beyond, went to the doctors 5 or 6 times before they would even listen to me as a parent to get him that diagnosis. So if it hadn't been for me going above and beyond for my son the entire time, no doctor would have even looked my way. I had to go to 5 or 6 different times, doctors and hospital and urgent care and whatever I had to do to get him this diagnosis. And so then that's where they exaggerated or lied, is because they said that my son's sleep apnea was life-threatening. Even though the pulmonologist says not, Cassandra Voida, nurse practitioner Voida, she did not go to the lengths she should have gone before she called CPS on me. She should have called the pulmonologist, and she should have had the information that I'm the one who wanted to keep the machine. He didn't necessarily need to be on it for medical purposes. I'm the one who wanted to keep the machine. She did not go to the length she should have gone to do it. And at every step along the way, Miss Voida, she has lied about me. Went as far as to try to suggest that I was using drugs or that I had scabs on my face when I brought my son to an appointment, you know, and that I had erratic behavior when I would bring him to appointments. Well, that doesn't even make sense, because she's a mandated reporter, and if she had had such high concerns and I had had scabs in my face or I had showed signs of drug abuse or mental illness, then she should have reported that as a mandated reporter if she had had those concerns. She only said those things about me after the fact. And it is my belief that she was upset with me because of disagreements and previous encounters we had had. And so that might have fueled why she said the things she said and why she provided disinformation.
And then I've got 2 questions. One's just a quick fact check. It hasn't been stated here, but I think I just want to verify this. It was your pulmonologist's testimony at trial that seems to have convinced the judge that this information was indeed wrong, that you had not neglected your child. I just want to check that fact. That's correct?
Yeah, yes, I would definitely agree with that. The pulmonologist, you know, provided that information at trial to, I believe that was the biggest piece of information. She was considered an expert witness. So what she had said, saying that no, she did follow up, she said the facts of what it was. Although Miss Voida should have done that before she called CPS on me and had my child removed from me.
Okay, I've got another question too, and this is going to sound challenging at first, but bear with me. It doesn't end up there. Earlier you said that the judge was going to take your kid away for a little bit longer because he was not sure if your household was safe or whether it was going to be an appropriate place, but that's not his rationale was, that you had not cooperated, that you hadn't provided your address, that you hadn't signed the forms needed for the child to receive medical care while in county custody. Now, I want to know what you feel about that your child was kept from you as a result of having been, of your obstinacy, of your rebellion, if you will, against the government. Do you feel that that's an appropriate way for a judge to rule?
I feel it was appropriate that he released my child, but I don't feel it was necessarily everything that was said or the way that was said or the way that I was scolded should have been, I feel like that wasn't appropriate and wasn't professional, because I have the right. One of the things he, in essence, scolded me for was having my lawyer present at every single thing. I had my lawyer, Mr. Cardell, present with me during the home visit in Wisconsin at my residence. I've had my lawyers with me this whole time because I feel intimidated. Before I started recording videos of the social worker, before I started going to the media, before I started reaching out to different people, they would say things about me and I would have no proof. They would say, well, she said this, and of course they're going to believe a CPS worker over me unless I have the proof, unless I have a video, unless I have a recording, unless I have my lawyer with me. So I feel like well, that's my right.
Were you expecting to take your child home that first day after that first hearing, which was August 31st?
Oh, absolutely.
So were you surprised when it went the other way? How shocked were you by that?
I was extremely shocked, because I went in there pro se, representing myself the very first time I went into court, and the judge wasn't Judge Wheiler, it was another judge, I don't remember her name, But she told me it wasn't that type of hearing for me to present my evidence. I had a declaration of facts, and I wasn't even able to speak my part. I wasn't even able to prevent, although it had been submitted to the court, I wasn't allowed to represent myself. And so I'm extremely shocked. My son should have been given to me. In fact, my son shouldn't have been taken. And if they had concerns about my son's safety, they should have kept him in my care, because there was no substantial evidence of harm or neglect, specifically medical neglect. So he should have been kept in my care.
I would like to ask about this in 2014, there was that big report on Eric Dean, who had been abused, and the child support did not remove the kid from and he subsequently died. Do you all think that development had a lot to do with child support being ratcheted up to the extent that it is now?
Yes, and actually the Commissioner Piper acknowledged that and said that we reacted. There were bulletins that were written that changed the way cases were handled. One of the things that I've spent a lot of time talking about was that rule-outs were suddenly considered and they were included in petitions. So prior to that case, any call that came into CPS that was screened out by the person on the phone saying, well, this is either duplicate or it doesn't sound legitimate, sometimes the calls would just end there. Now, with the new bulletin that came out between 2014 and 2015, the policy changed, and they could include every one of those calls into the Child Protection Agency in the petition. And the problem was that wasn't communicated properly to the judges. So the judges actually read these petitions from the county attorney, believing every one of those calls that were documented were followed through and investigated, and therefore now true and substantiated, and that there was going to be evidence down the road that would back those up. And in fact, that's not accurate. And I have a very significant case that I've worked on for years where that's exactly what happened. A grandmother was angry. She called regularly. They ruled it all out because they recognized that it was irrational.
Would you acknowledge that in a lot of cases, child support is needed because if the kids are not removed from the home, the child could suffer injuries or...
I'm not good at statistics, but I know that there is one. I believe it's 12% of children are actually physically abused in the removals, whereas the 59%, if I'm right, there's a 59% that's under the neglect or discretionary reasons by a social worker.
I don't follow you. I don't know what you're saying.
Meaning that, yes, of course there are cases where children are physically harmed and should be removed. Those are not the cases that we're arguing about. My understanding is that's about 12% of the cases that come into the Child Protection Department. I've heard that there's 59% that are discretionary reasons that they open the case, or the broad, vague, as Eric mentioned, neglect allegation. So that means that you have an individual social worker who can have a vendetta against the party, can be adversarial, can decide she thinks somebody's being too uncooperative, can decide she thinks the house is too messy. There's a case that the legislature was discussing where they came in and the cover of the fan was missing. Rather than remove the fan, they removed the child. That's up to a social worker's discretion. And that's the problem, is that too much of that is going on with unchecked power, lack of training, whatever you want to use as your explanation. My opinion is that it's the culture and the fact that they're federally funded for those removals. Every time they remove a child, it kicks in federal dollars. If they leave the child in place with a safety plan, they don't get to collect the same amount of money as if they remove the child. And so I'm going to stop there.
I'm going to do a fact check though on numbers and statistics.
This is your case.
No. Eric Dean was not, if you look at the statistics and just go to the DHS website and look at the out of care placement manual. They put this book out every single year on the DHS website. So last year they had 15,000. They have routinely for the last 15 years taken anywhere between, I think the lowest was like 11,500 children But in the last 15 years, they have never taken under 11,000 children a year. This past year was the highest at 15,004. So that was the most. But the year Eric Dean passed away, they had taken over 12,000 children in out of care placement. So they have 10 years on the website right now, on the DHS website, and you'll see that in the last 10 years that they have been taking these children. The Eric Dean was, it was a tragic situation. It's kind of interesting that the media went into this frenzy when more children die in this state on a daily basis on natural causes, not from child abuse and neglect. That was tragic. But to react to the point where you change all the laws to make it easier for child protection, when there was really nothing wrong with the laws in the first place. I actually went before the judiciary and I spoke before the task force. And I said, and I can send you those letters and the laws you have in place are not the problem. The problem is you're wasting all this time on families that don't need your assistance instead of following up on the families that do. When you have, 84% nationally, or in Minnesota, 64% of the children being removed from neglect, and then you have another 12% that's physical abuse. And now the physical abuse is as the social worker defines. All of those statistics are provided by the social worker before trial. That's something that no one knows, and I wasn't even aware of that until I started doing my research. So every finding that you see in those out-of-home placement plans and those statistics are all done before trial. And so I was shocked to learn that. I like to find out what happens after the trial. That's what I can't seem to find. I actually put in the Freedom of Information Act to DHS, and I actually requested, I said, how many of these cases went to trial last year, and how many actually were proven true, where the allegations were proven true? And I'm still waiting for that information. It's been about a week now. And then I'm going to present that also when I get that. So then we'll know.
So Eric, is there going to be follow-up litigation related to this case? Is that an open possibility, or is this case closed?
Yeah, Amanda's case was closed. The county attorney was asked by the judge in Morrison County, do you want the file closed? And the county attorney said to the judge, what do you think? And the judge said, I'm going to close it, which is good, because there aren't going to be any appeals in that case. I want to mention a couple of things came out, I'll just tie them together. The concern, of course, is that the trauma with respect to the separation of the child from the parent unnecessarily is also a public health issue. So it's a public health issue, child abuse, right? That's also a public health issue if Child Protection Services is taking children unnecessarily. In other jurisdictions, they've tried to find the right amount of out-of-home placements. We're being so ignored by the Department of Human Services and the County Social Services, they won't even recognize this as an issue. What do you mean? Well, you want the right amount of out-of-home placements. You don't want too many or too few. And in Wisconsin, as I mentioned, it's almost as if before the lawsuit's filed, they require an administrative determination of substantiation of the charges. And so that means that basically someone on the county staff is an ombudsman for the parents saying, well, have you talked to the medical professionals? Have you talked to the pulmonologist? That's not what happens here. You have a social worker with a BA, and then you have the county attorney working together. Maybe there's a supervisor involved, and all they have to show to take the child is an allegation. There isn't an administrative determination before the lawsuit that the claims are substantiated or unsubstantiated. Then secondly, and as important, is that we don't have a requirement before taking the child of a substantial harm to the child. An ordinary bottom spanking, neglect, it doesn't need to be tied to substantial harm to the child. They just allege there was corporal punishment, or they allege there was neglect, and they don't have to prove until the trial. And even at trial, they don't really need to prove that there was substantial harm connected. So then the most disappointing thing about the judge's order, where medical neglect was not found, but the child was kept for immaturity and for being a danger to the child, is it wasn't connected to evidence of substantial harm to the child. And Judge Loken, in a 8th Circuit opinion issued on August 10th, an Arkansas case, as the U.S. Court of Appeals for the 8th Circuit said, it is well-established law in this United States, in Minnesota, that if there's not a reasonable suspicion of child abuse, that's unconstitutional for the government to take the child. Now, this seems so obvious to Minnesotans who live in small towns, the suburbs, and the city, that the government can't take a child from a parent unless there's reasonable suspicion of child abuse. But that is so far removed from our experience with child protection services. I mean, it's like, I'm speaking when I say that from Venus or Mars. They don't understand that. They have a completely different standard in their mind where they're protecting children by grabbing them. They deny, despite medical evidence, that this would cause any trauma to the parent and child while they have the child, and then they go to the CHIPS trial. Now, at the CHIPS trial, you have government-funded lawyers all over the place, and normally, the parent is either not represented or poorly represented and just can't win the day. And remember, it's not like a proof beyond a reasonable doubt standard in a criminal trial. It's preponderance of the evidence, and the government really goes all out in winning these cases. So what generally happens is, this is what we're seeing is, they take the child, then there's all this confrontation, then at the CHIPS trial, if they win, then there's frustration, and then ultimately the parental rights get terminated. So a lot of these cases, when you talk to our members, they've had their parental rights terminated and they're not sure why. And we need a better process than that, because when you start off with a process that doesn't require substantiated evidence of substantial harm, you end up getting children taken for bad manners. So let's look at Amanda's case in a different way. What if Dr. Voida didn't like the way she interacted with, or nurse practitioner Voida didn't like the way that Amanda interacted? And that was kind of the sense of trial. We had 3 days of trial. The pulmonologist testimony went in, basically that the Xavion's sleep apnea had resolved prior to the emergency room visit. And then the county didn't withdraw their charge, right? They said it's still medical neglect. So they contradicted medical evidence in this particular case. So why would you trust the Department of Human Services or any county child protection agency on any medical issue? Because they contradict medical experts, including the most important ones, and those are that there's trauma when you separate a child from a parent, and that shouldn't be done if it's unnecessary.
Following up on the question I asked, is there any possibility that she may be added to some sort of federal civil rights suit?
All right, Dwight in the hub and spoke that I mentioned before, the plaintiff association is the plaintiff, and prior, when we filed, Dwight filed his lawsuit, he included the members of the association, and so Amanda had submitted a declaration in support of the lawsuit, and so her claims are already in the lawsuit, as are all the other members. And the Department of Human Services vigorously contested association standing because they don't want to have that review. But in the federal courts, we have examples of the NAACP, we have examples of the American Civil Liberties Union, and other examples of association standing being found. It's sort of a routine thing. So here the Department of Human Services wants to even deny the parents that right.
I have one more question for Amanda, if she can take it.
Amanda?
Thank you for accommodating me. You say that you're going to continue to fight, and maybe you want to clarify that because I suppose some people can hear that as a threat. But what do you really mean? Are you going to seek legislation? Are you going to appear at the legislature for testimony? What kind of fight do you intend to wage?
Well, I intend to do whatever it takes to hold the social worker and the nurse practitioner, the primary care provider, accountable. Now I would have to speak with my attorneys on exactly what I can do legally, but I will go to the full extent to make sure there's some type of justice for my son Xavion.
Do you think you might appear here at the legislature? You did talk about changes to the law.
Yes, I talked to Dwight, I've talked to my attorneys about, I'm not sure exactly how I can help in that way, but I know that my case and sharing my story can make a difference in bringing awareness to the public is one thing I really, really want, because, getting my son back was my main goal, but it's not enough to make me feel okay.
How many did
Because
you
I-
file the complaint with the Board of Social Workers. So
I
she's
did.
already done that. So she's already started down that path, and it's under review. You have to mention that.
Yes, I filed a report with the Board of Social Work against Katie Canetto. I guess they found enough reason to do an investigation on her.
Is that Divya?
Yeah, this is Xavier, this is my son.
Do you mind if he's photographed?
I don't mind.
We had brought some of the other parents, actually, that we've helped get their children reunited also. I mean, I was hoping to do a photo with all of the rescued children. Is that something you'd like?
Sure. Good, should they come up?
Mara, Daisy, you want to come up with your children? Maisie? You want to come on up, Maisie?
Come here, Mimi. Come to Mama. Should we stand right here? Where's the sun?
Yeah, we can all stand here. Can everyone see us? Can we get come a little bit tighter? Hello. Daisy, yeah, a little bit tighter, a little bit tighter.
Closer, closer.
Closer? Okay. Thank you.
Thanks, everyone.
Thank you, everyone.